We are here to talk about the NAR settlement and the new era and the changes that are here now. I also will be repeating all questions for a couple of reasons, because typically not everyone in the room can hear them, but also this is being recorded today, and so I think I'm the only one mic'd up, and so if I don't repeat them, then those folks watching the video later won't know what those questions were. But let's get started. This case background, just to start with a little bit of background, the case actually started in 2018. A lot of people didn't hear about it, didn't know about it at first, so it took a few years before this case really got noticed. And it was certified along the way into a class action, meaning there were named plaintiffs, but along the way, a court agreed that there may be other plaintiffs that were similarly situated, and so they established a class. And the allegations, and it's important that you understand, even if you don't agree with the allegations, that you understand the allegations, because they really give a lot of context to why the settlement looks the way it looks. So the allegations were that the industry engaged in antitrust actions. So that is anti-competition, price fixing, or colluding, and that the sellers and especially buyers didn't have the opportunity to negotiate and set their own representatives' compensation in a transaction. And that the MLS rules, by requiring sellers to make an offer of compensation to buyer representative, that the MLS rules really supported the fact that that buyers and their agents didn't have an opportunity to negotiate and set their own rates. And that because of this, the prices were inflated, at disclosure of the commission or compensation structure in the MLS, as was then required, that this led to people shopping, to realtors shopping for prices. So I want to take a quick minute to talk about these allegations. Number one, the allegation being that there was price fixing. And number two, that then realtors shopped for properties based upon the price available to them as the representative for the buyer. Think about that. Why would I need to shop for a property based on price if the price was already fixed? So you've got diametrically opposed allegations going on here, and that's pretty common in a lot. The attorneys representing on the front end don't know what's going to get traction and what's going to stick, and so it's not uncommon to see very diametrically opposed allegations, only to later find, okay, this is sort of what really gained traction, where there was proof and evidence behind it, and the other allegations fell to the wayside. But not in this case, guys. It's not uncommon for there to be diametrically opposed allegations, but usually you can't have both ways, and that's not really how this has come together. As this has come together, as you all now know, in October of last year, a $1.78 billion with a B billion jury award came down. That was 8 jurors who determined that yes, there were damages to the plaintiffs and all similarly situated class participants, and that was the appropriate award. It is important to note that of those 8 jurors, the reason we are sitting here today, 6 of them have never engaged in any real estate transaction before, as a buyer or as a seller. Think about that for a quick second. In November, when you realize that there's that kind of pool, right? When you realize there's that kind of money pool, dozens of copycat lawsuits emerged. In December, the judge started to award preliminary approval for the various companies who settled out. Anywhere family of companies, which is the Coldwell family of companies, for $83.5 million, Remax Holdings, $55 million, Keller Williams, $70 million. In March, the big NAR settlement, where many of these terms were formulated as part of that settlement, they settled for $418 million. And then following that, in April, Home Services, which is the Berkshire family of companies, settled for $250 million. If you're a math whiz, you realize that the combination combination of these settlements is approximately half of the original jury award. And that was really everybody recognizing that, as a plaintiff, why would I take half? Well, I certainly don't want people to go bankrupt. It doesn't help me if they can't pay on what they owe me. But also it helps everybody to stop the litigation, stop the appeals, so that they can continue on to the result and the resolution. So that's where we are now. The settlement agreement that was reached by NAR, it releases covered parties from liability. Nearly every realtor is covered by the release of liability in realtor associations, realtor association-owned MLSs. Covered parties must agree to certain practice changes in order to be released from liability. So if you do not engage in these practice changes, you will not have the coverage of the settlement, and you are still subject to liability. Preliminary court approval of the settlement terms was granted in April of this year, and the final hearing is scheduled for this November. Revised MLS policies will go into effect on August 17th, so just a couple weeks away, and this happens to also correlate with the earliest date for class notices. A couple things that have emerged along the way. Number one, Cincinnati is revising their MLS on August 6th. So on August 6th, the fields in their MLS that correspond with these settlement terms will be modified. And for Dayton Realtors, that's August 8th. So on August 8th, certain fields will be changing in the Dayton MLS. MLS changes in part of this settlement require the following. First of all, that it eliminates and prohibits participants, subscribers, and sellers from making any offers of compensation on the MLS or related fields, and to the buyer brokers and other buyer representatives. To require that the MLS not create, facilitate, or support any non-MLS mechanism, including providing listing information to an internet aggregator's website for such purpose, for participants, subscribers, or sellers to make offers of compensation to buyer brokers and other buyer representatives, and to reinforce that the participants and subscribers must not, and that the MLS must not, enable the ability to filter out listings or searches based upon the amount of compensation. Now, I want to make something perfectly clear. It is not appropriate for you, for your own benefit, for your company's own benefit, to filter or shop on behalf of the buyers based on how much compensation you're going to receive of your own volition. But that does not stop your client from saying to you, I want you to find things that correspond with these terms and conditions. If you are shopping at your client's directive, you can certainly take actions to meet the requirements that they've set forth. Just like a client who tells you, don't put me in that school district, put me in this school district, don't put me on that side of town, put me on this side of town. You can certainly search for listings that otherwise meet their criteria, but that also correlate with any type of compensation criteria that they might set forth. All brokers, agents, and representatives must enter into written representation agreements with buyers and sellers prior to representation. Now, I mentioned at the outset that as we've progressed through these classes, Ohio passed House Bill 466. This will require all Ohio brokers and representatives, regardless of participation in the NAR settlement, to enter into representation agreements, written representation agreements with your clients. So this levels the playing field. For somebody that might have otherwise said, hey, I'm not part of that, it doesn't matter. Under Ohio law, once this is signed into law and goes into effect, they will be required to have written representation agreements. A side note, it also includes any lease arrangements of 18 months or more. I will say that the documents that have been created are not created around leasing arrangements. Those forms will have to be created and introduced down the road, but it is important to mention that. The representation agreements must conspicuously disclose to the prospective client that broker commissions are not set by law and they are fully negotiable. And added, in accordance with this House bill, that these commissions or fees may be paid by either the seller, the buyer, the landlord, the tenant, or a third party, or by sharing and splitting fees and commissions between brokers. If you are a listing agent, you must disclose to buyer's agents at the earliest moment possible any offer of compensation that is being made in connection with an active listing. So your clients will not be required to make an offer of compensation, but you have to disclose that at the earliest moment possible, but not on the MLS, which might be the most efficient way to communicate that. You may not disclose, overtly may not disclose any offer of compensation on the MLS or other fields in the MLS, meaning attachments, showing time, anything touching the MLS. Do not have any offer of compensation. Don't get clever. I know I've seen these cute memes that have like, we're just going to capitalize certain letters that spell out THREEPERCENT. Funny memes, but please don't do that. Please don't try to sidestep it. The MLSs have been charged under this settlement with enforcement. I will tell you that the fines will be very steep. In Dayton, for example, the first offense will start at $1,000 fine and quickly go up from there, including suspension. So please, it is not something to test the waters or oopsie doodle. Your written listing agreement must state the compensation to be earned by you, but it must also disclose and permit any offer of compensation to the buyer's broker or representative, whether that offer is going to be paid by you out of your commission or will be paid separately by the seller in addition to what they pay you. You may disclose compensation on any other advertisement or source, again, as long as it's not an internet aggregator. What they don't want is to prohibit all this on the MLS, only to find out that someone creates MLS 2.0. We're not going to do it on the MLS, but we've created something that substantially does the same thing as MLS, and we're just going to do it over there. So that's expressly prohibited, but you can otherwise disclose it in any way, shape, or form. You can put it on the sign in front of the house. You can we've got forms here today that you can leave inside the house. You can put other signage inside the property. You can put it on your own website or your broker's own website. You can state the offer of compensation for your own listings or your broker's own listings. You can wear a t-shirt, you can tattoo it on your forehead. You can do this a million different ways, but not on the MLS or other internet aggregators. You may disclose other non-compensation seller concessions on the MLS. So I wish concessions didn't sound so much like compensation or commission, but other concessions, think of carpet allowance, home warranty, closing costs. You can say something generic like for any purpose permitted by lender, which maybe the buyer will ultimately end up electing to use those towards compensation, but please don't do it with a wink wink. This is where I'm really trying to tell you about the offer of compensation. It's intended to be for other non-compensation related concessions offered by the seller, and those can go on the MLS. Buyer's agents, of course, now you must enter into a written representation agreement with the buyer before touring the home. This can be a single arrangement, single property arrangement. Maybe you get a lot of Zillow leads. Maybe you're going to get a buyer who's referred to you and you haven't had the opportunity to establish a relationship and to create a meaningful dialogue, and you say, I don't want to create a broader agreement, but we can do it just for this one property, and you'll see that the forms here today are suitable for that. But you are going to need to very carefully consider how are open houses going to run if you might be representing the buyers coming through. We'll have some time to talk about open houses, and I prefer to mostly leave that till the end, but I will say, when you are thinking about implementation of these rules, please don't overthink certain things. Please recognize that you're never going to represent a buyer that is already represented. So that none of this is to suggest that every buyer that comes through your listings, let alone an open house, has to be represented by you. They may be represented by someone else. You're always going to ask, are you represented? Important now to ask that and to confirm that. You're also going to always consider, is dual agency something that I want to engage in, and is it something that my client on the listing side is even comfortable with, because if not, then you are definitely not going to be representing those buyers. But the issue comes up when you do have the opportunity to represent those buyers, whether through open house or them calling you off of your sign or other advertisement, where if they are unrepresented and if you are interested in and permitted by your client to engage in dual representation, how does this look so that you can enter into a representation agreement before you tour the house with them, before they tour the property with you as their representative. The compensation amount in your agreements must be stated, and it must be objectively ascertainable. You cannot create an agreement that says anything that the seller might pay me, anything from this percent to that percent, or this dollar amount to that dollar amount. Now, if you have something tiered where it's very clearly ascertainable at what point would you be paid this, at what point would you be paid that, or the next tier, then that might be permitted. These forms aren't really well suited for that type of arrangement, but you can do it as long as it's objectively ascertainable. It cannot be open-ended and ambiguous. And you may never receive compensation for your services from any source, whether it's from the seller, your client, from the other realtor, or any other source that exceeds the amount or rate in your representation agreement. So as you'll see in the forms today, we've got the base representation agreement and we've got an amendment to that agreement. When we were first starting these classes, we were being told that you could only amend your agreement to lower your compensation. We have since received very clear guidance that it can be amended after the original agreement to lower or increase your compensation. So if the seller's offering a bonus or if there's some other stance that warrants it. So that's good news. You may not advertise or represent that your services are free unless, in fact, you're not receiving any compensation from any source. I know that's been something for people to say through the years. Don't worry about it, I'm free. I don't know that's the best expression of your value, right? You all add a tremendous amount of value to your clients, and so to say that you're free really doesn't express that value. So unless you're receiving zero compensation, you certainly cannot state that or advertise that. Dayton Realtors has taken a very proactive stance in getting the forms that you have in front of you ready to go. Generally speaking, and I mentioned that I've represented them on the forms for many years, it takes several months for just one form to be created and pass through the various committees and obtain approval. The forms that you have in front of you were not shortcut. It just means that they worked the same amount of hours in a condensed period of time. They worked very hard so that these could be created, so that trainings could start and you all could become familiar with it. I'll say somewhat conversely, Cincinnati, I think, is just now finalizing their forms and hasn't even started training, even though the MLS fields are changing on August 6th for Cincinnati. So if you see someone on the board or you see someone on the forms committee, please thank them because they have worked diligently to get these in front of you. So let's dig in. The exclusive right to sell contract. So the exclusive right to sell, and these forms that the package is given to you or sent to you, we're going to go through them in the exact same order. We're going to go through them in the same order. As I was mentioning before we got started, please read these forms. Become familiar with these forms so that you do know these forms like the back of your hand. These are tools of your trade, and it's important that you know them and understand them. And you'll see right at the top, we've got the required disclaimers, both based on NAR and House Bill 466, that broker commissions are not set by law and are fully negotiable, and that these commissions or fees may be paid by the seller, the buyer, the landlord, the tenant, or a third party, or by sharing or splitting the fees and commissions between brokers. You're going to see this also on the buyer representation agreement. And then this first paragraph is where you start to put together the agreement with your client. Now, anytime that you're required to make some changes, it's a good opportunity to make other changes that solve problems that may have had nothing to do with the precipitous. So in this case, we had other pain points for realtors based upon the listing agreement, and so we've tried to solve some of those with some of the language in this agreement, and most notably in this first paragraph. So you're going to identify your clients, certainly the date of the agreement and the seller, who is the owner of the property, and then yourself, meaning your brokerage. But then they are going to represent, first of all, that they are not bound by any other exclusive representation agreement for the real estate that is described in the agreement, and that the persons or entities named in this agreement represent all owners of the property. I can't tell you how many times we get to closing, we get on the title side, and we find out that the contract, and before that the listing agreement, was only signed by one owner. And also this goes on to say that that person, if it is a non-individual but an entity, that the person signing the agreement have the authority to sign the agreement, and that they will provide you with that proof. So if it's a trust, they're going to provide you with verification of who is the trustee or the trustees and their authority to sell the property. If it is an LLC, they're going to show you who is the owner of the LLC and their authority to sign documents and sell the property. Executor, same type of thing. If you don't know how to evaluate these documents, please work closely with your title company or your title attorney so that they can assist you on the front end of a listing, so that you know you are getting all the correct parties on your agreement and that they have the authority. Also important, because we are in Ohio and we are a dower state, that you know if the seller is a natural person, and that means Ann Taylor acting for Ann Taylor, not Ann Taylor acting as an executor of her mother's estate or trustee of her own family trust, or on behalf of Taylor Properties LLC. But Ann Taylor selling as Ann Taylor, I need to tell you if I'm married. This is a conversation to have on the front end of the transaction before you spend a lot of time and your money taking pictures and advertising the property only to find out that I'm estranged from my spouse and haven't talked to him and her in over 10 years. That's going to be a problem for your transaction. So this is the time to get that out front, and then I'm going to identify that at the end of paragraph 1, any and all spouses of any and all owners who are natural persons. But then as we go through the exclusive right to sell, on line 18, you're going to identify the street address, the lot number, and any and all parcels. This is another pitfall of realtors where you just say, okay, this is 123 Main Street that we're listing, and nobody bothers to look at the deed. Is 123 Main Street one lot, two lots? Are you intending, even though it may have, both lots may be assigned to that property address, is the seller intending to sell all of those lots? Or are they selling only this primary lot and this other one they've already sold to a neighbor, they've got other plans for it? Conversely, did I originally buy just this lot, but along the way I put in a swimming pool or an addition and I had to buy a 10-foot sliver from the neighbor, and you just pull up my original deed and you don't bother to see that I've got an additional parcel? So have conversations with sellers about when they acquired property, how they acquired property, if they have copies of the deeds, or again, your title company can help you in trying to identify any and all parcels that need to be identified as part of the sale, and of course excluding those that they're not intending to convey. They are going to, any real estate, and as your contracts are written, is going to include fixtures of pertinent rights. But if there's fixtures that they intend to exclude from their sale, they can identify that right there on your agreement, lines 20 and 21. As you all may know, it's really good practice to just not let a buyer ever see those things. I'm going to be sure as the buyer that I was never ever going to buy this house but for that chandelier. That's now my favorite thing I've ever seen in the world, because that's the one thing that's not going to convey. I say early in my career I would have been able to retire on bathroom mirrors. Right? This buyers just only loved the house because of that bathroom mirror, and the seller, by golly, was not satisfied with the hundreds of thousands of dollars on the sale price if they had to include the mirror. So please be very clear what does and doesn't stay. It's now often, and though this isn't a fixture, but it's now often washers and dryers. I see people having washers and dryers. So anything that is not going to stay, this is a place for them to exclude it. Now, in this paragraph and throughout these agreements, we say over and over again a warning to sellers that even though this is your marching orders under the listing agreement, and though you'll advertise it accordingly, that they should carefully review the in complete terms and conditions of any contract, because this listing agreement, any other MLS or other advertisement do not govern what the agreement is between buyer and seller. That's only the contract. So what the contract says is what the seller and the buyer have agreed to do. So that is critically important, that if the seller is planning to exclude something, that you're bringing it to their attention if in fact the buyer has written it in or failed to exclude it. As we go through there, if you are going to make this agreement specific only to one particular buyer, maybe one couple down the street. I mean, parties have never had to hire realtors before for the listings or to represent them as the buyers. They do this because they know you add value, and they pull you in sometimes even when they don't really need you to market the property. They need you to help them price the property. They need you to help them understand all of the moving parts of a contract and a transaction. They need your expertise. You add a tremendous amount of value. So here is where you can select if a seller has brought you in only for specific buyers. My neighbors want their children to buy this property, and we're going to write it for this. Now maybe if that's the case, the term of the agreement's different. Maybe you only make it a shorter term agreement if it's specific to certain buyers, because if they don't come through and they don't buy it, you then are going to start to do things to market and sell the property for this seller. And maybe that's at a different level of compensation, but that's for you to negotiate. And if you're going to make it exclusive only to certain buyers based on the terms of the compensation, then 26 is where you'll check mark that, and then you'll identify that. We tell the seller one more time that any natural spouses do have to be included in the conveyance. The seller is then going to go on to authorize you to market this property very broadly in any manner, location, medium, and if there is a type of marketing that they would like to exclude, they can communicate that and you can agree to that there on line 32. Maybe they don't want it on social media. We've got a separate area in the contract as previous listing agreements where they'll authorize signage and lock boxes, but maybe this is where they tell you, hey, I don't want this to go into a certain type of publication or, like I said, social media. But the listing period is going to then be identified in section 2. You have a start date, you're going to have an end date to it, but what was added to this agreement from one of our first classes is that the MLS committee had some concern that people may have forgotten that regardless of what you put here, it does not change the standard MLS rule that you have to upload it to the MLS within 72 hours of the date last signed. So there is a notation at the end of that section 2 there just to remind you that that is the case. So if you have some sellers that are going out of town and you just want to get this paperwork ready ahead of time, or you know what exactly the agreement you're going to put together, but they still want to finish painting some rooms or cleaning some carpets, then you be the one to hold off on signing it until you're inside of that window. But once all parties have signed, you do still have to honor the MLS rule to upload it within that period of time. If you go on to the next page, section 3, the terms of the sale, pretty straightforward, is where you're going to identify the listing price. And again, we say at the end of that paragraph, this does not stop a buyer from offering terms or conditions different than what the seller has indicated in this agreement, so a seller should always carefully review their agreement. But now let's get on to the most important part of this agreement as to the context of our discussion here today, and that is how do we go about establishing the fees? In section 4, you're going to establish the fee that will be paid to you and your brokerage as the listing agent. This is the fee that will be due to you regardless of any offer to a buyer or buyer's broker in section 5. But I'm going to caution you, do not fill this out in section 4 until you have thoroughly discussed how this offer is going to look in section 5 and thoroughly considered how things might work if you end up being the only representative in the transaction. because you either are a dual agent or you're the buyer comes unrepresented and you only represent the seller, but just because you only represent the seller, you know that that still means that you're doing at least twice the work for a buyer who's unrepresented as well. So please carefully consider all these scenarios as you start to agree to your compensation in Section 4. Now we've got 3 areas where you can insert it. We've got a flat dollar amount, we've got a percentage, and then an additional dollar amount for a transaction, an admin, technology fee, whatever you or your company calls it. All of those can be inserted. This isn't to suggest that in a typical listing, most sellers are going to agree to all 3 types of compensation. It's simply intended to be adaptable to a situation where maybe you have a flat dollar fee and your technology fee, or you have a percentage and a technology fee, or only one of these. You will see that it says this and this and this, because legally we don't want to say and or, because which is it, and or? So it says and, but it expressly says that any areas left blank will be considered 0. 0, which there's no problem with you inserting 0 or putting a line through it as well. There's also going to be a terminal period on line 54 that if you sell within the term of your agreement that you've already established, or if a buyer that comes through within so many days, based on that terminal period, what you insert there, that you're still entitled to that same compensation that you've inserted in Section 4. These agreements go on to say that that's not just for any buyer, but any person who might buy on behalf of that buyer. We don't want clients to utilize these agreements cleverly to sidestep a realtor. So if Ann Taylor came through and looked at your listing, and then the party sort of said, hey, this listing agreement's going to expire in a day. Why don't you hold tight, Ann, before you come through? But then I think as a seller, there's a terminal period. So Ann Taylor just gets really clever and sends her parents over to buy it, or her husband over, or she creates an LLC to buy it. This is anybody or any entity buying on behalf of that buyer, that terminal period would still apply. But as with the last listing agreement, that would not apply in the event that the seller goes on to sign with another brokerage. So if they sign with another brokerage, the terminal period does not apply, but otherwise the terminal period will apply based upon what you insert there. But in Section 5 is now where you're going to go on to determine, is your seller going to make an offer of compensation to a buyer's agent, or are they not going to make an offer? And if they are going to make that offer, is it going to come out of your compensation, what you've already agreed to up in Section 4? Or is it going to be in addition to what they've agreed to pay you in Section 4? I've used this story before, and I think it's important to note. Think of this like baiting a hook. When we were kids, we used to do all sorts of ding-dong things, but one of which was we would put paper clips on a string and a little stick, and we dip it in water, and kind of nothing happened. No little creatures were all that interested in it. You might scare something that was there, but nobody was biting on that, right? Somebody would get smart and squish like a worm or a bug on it, and now we might have something come around and sort of nibble at it, but we probably still weren't catching anything. If we really wanted to catch something, or wanted to catch the right kind of fish, we were going to bait it properly, we were going to have the right equipment, and we were going to do this the right way. And that offer of compensation very much works like that. People are looking for the easy button, not just agents, though the settlement might suggest otherwise, but the buyers are looking for the easy button. Do I have one more thing to negotiate? If as a buyer, because we're going to find out they of course are going to be on the hook for any compensation, if as a buyer I'm concerned about the type of compensation or the amount of compensation, because either A, I don't really have the cash reserves to pay that compensation, so that might hinder my ability to enter into with the seller that's not going to pay it, or maybe I have a loan type that doesn't permit me to pay the fees. VA did come out, again, during the pendency of these classes, VA came out to say that they were putting in a temporary rule change where they would permit buyers to pay compensation. Historically, buyers weren't even allowed to pay 1 penny of compensation, no matter how it was categorized. they can now do that, but it cannot be included in the loan amount, and they must have that money otherwise. So you're still going to have a lot of buyers that maybe can't pay their own compensation, or their loan terms somewhat restrict how that gets paid. As a seller, do you want to attract the most buyers possible, or only a certain few who can pay their own compensation? We are in a military town, one of the largest military bases in the world. Do you want to appeal to the widest number of buyers that may be from that community, or do you want to disenfranchise some who may not be able to qualify? So it's important to have these discussions with your seller, and your seller ultimately is going to decide what they do or do not want to offer, and you're going to decide whether this is an agreement that you're comfortable with or not comfortable with entering into. But as you go through this, in lines 70 and 71, and there's a little cross symbol that's further identified below that they can read for themselves, but it's a little cross symbol that says anything on lines 70 and 71 is going to come out of the compensation offered above or agreed above in section 4. But anything on the next two lines, 72 and 73, is going to be paid in addition to the compensation above. So how is this going to work? And is it easier for the seller with all the other pieces and parts that need to be negotiated to simply have the sure thing of, here's what I've decided to pay my broker up in section 4, and anything made as an offer to the buyer's representative is going to come out of that? Or are we going to have to negotiate this, and I can make an offer to be in addition to it, but we're still going to have to negotiate that through? Explain this to your clients so that they understand that. We also go on to say that just because an offer of compensation is or isn't made, or however it's made, doesn't stop a buyer from coming along and still trying to negotiate different terms. But you certainly know what's standard market compensation, and if that's coming out of your compensation, then it doesn't need to be further negotiated between the parties. Let's go through some examples of this. So, section 4, and I am going to use, I know a lot of people, again, for fear of this antitrust, they want to stay away from talking actual numbers. So we talk about apples, getting paid apples, or getting paid, cotton balls. We're going to talk about actual money, but that's not to suggest that these are the amounts you should insert and that it's not fully negotiable. Okay. Section 4, let's say you're going to agree with your client that they're going to pay you 7%. So up in Section 4, you agree to 7% compensation being paid to you as the listing broker. And maybe there's a technology fee, maybe there's a not. But then down in Section 5, if they insert 4%, they're going to make an offer of 4%, and they put that at 51, then that's coming out of your compensation above, which would mean that if you have an eligible buyer representative agreement to receive at least 4%, then that offer of 4% would be paid to the buyer representative, and you would get the difference, which of course would be 3%. But regardless, your seller is paying a total of 7%. Conversely, if they put 7% up above, but somebody puts it down on line 73, down at the bottom, now that's going to be paid in addition to. So 7% would go to the listing broker and 4% to the buyer's broker. I don't know a whole lot of sellers intending to pay 11%, but that would be the result. So it's important to work through the math. Where are you putting this? Is it in addition to what's in Section 4, or is it coming out of what has been agreed to in Section 4? Another example, let's say Section 4, you put 2% up above. So if you put 2% in Section 4, and then you want to put what is an offer to the buyer's representative, and if you would put that on line 72, it's coming out of yours up above. So if 2% is offered to the buyer's broker down in Section 5, coming out of your compensation in Section 4, and both are 2%, that's going to net 0, but the seller is still only going to pay 2%. Probably what you would mean to do in that scenario is that you would agree to 2% going to your brokerage as the listing broker, and then 2% or some other percent in addition to, but with the 2 and 2, if you put that second one down on line 73, then the seller's going to pay a total of 4%. So again, just making sure that it's very important that you know whatever you agree to in section 4, whatever offer is being made to the buyer's agent is either going to come out of that, and I'll say sort of a la historical commission or compensation payments, or it's going to be paid in addition to that. So again, anything on lines 70 and 71, they do not need to be further negotiated between the parties because they're already coming out of the listing broker's compensation. It's being paid out of the listing broker's compensation. It doesn't need to be further negotiated on the contract or otherwise. But anything on lines 72 and 73, that offer still needs to be accepted, and that does need to be confirmed and negotiated between the parties. But anything that is paid by one party that is, if you're not asking the other party to do anything over and above what their existing agreements already state, you don't have to negotiate it. That's why lines 70 and 71, you don't have to further negotiate the compensation. But please, please, please do the math, because if you put something on line 70 or 71 that would exceed what is in section 4, then you've got a problem. Now you're pushing something into the negative. So I hope that makes sense, that if it's coming out of yours, what's the net effect? And so run through the math real quick for yourself and for your clients. All right, we can move on to the offer of concessions in Section 5. Section 5 is concessions. Your clients don't have to make any concession offers. It is very common for a seller to not make any offers of concessions right up front, but still a buyer might negotiate in seller payment of closing costs or a home warranty or title insurance or something else. Your seller doesn't have to do that, but if they wish to do that, if they say, no, I want to make it abundantly clear that I am going to offer some concessions, then that is what Section 6 is for. This can go on the MLS. Concessions can go on the MLS. Unlike compensation, concessions can. So on line 88, they might say, let's go ahead and make an offer of X number of dollars for closing costs. 88's hardwired for closing costs. 89, they might say, for a different purpose, I'm going to pay $795 for a home warranty, or for a carpet allowance. Or you might just put in a generic statement for any and all items permitted by buyer's lender. Please keep in mind whether you qualify concessions that way or not, whether agreed to on the listing agreement or later agreed to in your purchase agreement. It is important, if it's being financed, that it's always subject, that you understand it's always subject to the lender's approval. If it's a cash deal, they can do whatever they want with regard to that. But if it's not a cash deal, it's always going to be subject to lender's approval. But you can leave it open for any purpose permitted by buyer's lender. Any questions there? We're moving fast through this. So you're drinking from a fire hose. Okay. Other key terms. So those terms are the ones where people spend a lot of time, but that doesn't mean you should ignore the rest of the terms. So we've got some areas where the seller's going to make some more representations in Section 9. If there's any tenants in the property, this is the place to communicate that. Fair housing statements in Section 11. This is a great opportunity, I think, for you to discuss as a listing agent the pitfalls of receiving what I always call buyer love letters. HGTV loves to say, oh, write that letter to set yourself apart, to say what wonderful people you are. But I would tell you that the love letters, these types of letters, are pitfalls for fair housing violations. There are many communities, MLSs, and even some states where these types of letters are strictly prohibited, because nobody writes the letter to say, I just really love your lot size. I just like how the the home is squared up on the front of the lot. Maybe they'll comment on historical features if it's been a renovated home, but they usually write things like, oh my goodness, I see that you raised your 4 boys and a girl and 2 dogs and a gecko here. I've got the same thing. I see you're a member of this synagogue. We go to the synagogue just down the other street. Or maybe we go to your same synagogue. Oh my gosh, I'm so glad you've got an American flag. We're proud Americans, right? All things that absolutely violate fair housing. They are not to be considered in your seller's transactions. And if you're going to not present those aspects of an offer, your seller needs to indicate that to you up front. It'd be a good time to have that conversation. The rest of this agreement goes on to say things like electronic surveillance devices. This was added last year to the listing agreement. Please become familiar with this. It's a whole class in and of itself. And in Ohio, if you legally surveil someone, it doesn't mean you are permanently recording it even, but if you illegally surveil them, limited circumstances on video surveillance, so there's much more leeway there, but any audio surveillance where a party hasn't consented to it is illegal, and those offenses are felony offenses. As realtors, you can also be held liable if you, in fact, utilize that in any way in the negotiations. So these are important things to know and discuss with your clients on whether or not they have these kinds of devices and whether or not they're going to leave them on. Miscellaneous is where you go on in section 15 there to say, are they going to consent to the for sale signs or to lock boxes on the property? So the rest of that agreement goes on to very standard things, but becoming familiar with how the compensation is stated, whether or not there's going to be an offer of compensation to the buyer's agent, and is that coming out of your compensation, or is it going to be paid in addition to your compensation? Did you have a question? Just stretching? Go ahead. Okay. It's like an auction, folks. You raise your hand, you buy. So the question is, in these lines of the offer of compensation, 70 through 73, why does it say and? Again, because we aren't going to say or, and it needs to be clear, do all of them apply? But anything left blank will be deemed 0. So again, I certainly don't expect in a majority of transactions, or even maybe ever, that you will have all of those lines filled out, but theoretically, your client might be offering to pay a flat rate amount of, say, $275 or $295. Maybe they're doing that with an eye towards, hey, a buyer might have a transaction fee or a technology fee, and I'll also make an offer to pay X% of the compensation to the buyer broker. So it's intended to be and, but it's not with an eye towards your client's likely going to fill all of those out. They're probably going to do 1, possibly 2 of those areas. Yes? Yes. Existing listings, and thank you for asking that. It was asked in advance, and I promised I would make a point to mention it, so I appreciate the reminder. As I mentioned, the settlement terms go into effect later in August, but the fields will be removed from the local, I'll speak to Dayton MLS, on August 8th. What do you do if you have an existing agreement when these changes go into effect? Either the MLS fields are removed or the settlement is approved, but you've still got 3 or 4 months left on your existing agreement. Your agreements are not void. They are still valid agreements. You do not have to change any listing agreement that you already have in place. What you do have to recognize is that the way that you communicate that is going to have to change, at least locally, as of August 8th, because where you presently are going to insert the amount of compensation being offered to the buyer broker, if any, in the fields in the MLS, as of August 8th, you're not going to be able to do that. And so all of you are going to need to be thinking, if there's an offer of compensation to the buyer's broker, How am I going to communicate that once those fields are removed? Either because I have the new agreement, or simply I have the old agreement that's still in effect, but how do I communicate that? How many people here want to get 5,000 phone calls the first day that their listing goes active? Right? That you don't want to have to answer that. Who wants to be on the other side of that trying to reach this seller or listing, or the seller's agent, the listing agent, who has made to find out what the offer of compensation is? Find efficient ways. A lot of brokerages are establishing, just for their own brokerage, listing websites that properly disclose the offer of compensation. Some of them are organizing them based on the offer of compensation. If that's what your broker's doing, it's certainly a conversation to be having with your seller. But find efficient and effective ways. I think of those talking houses where you used to drive by and you'd like type in, such and such number. Maybe now it can be a text or something. And off of that sign, it tells you what the offer of compensation is. But you can't necessarily drive around town to get all of those. So find the effective, efficient way for you as the listing agent to communicate at the earliest time possible what that offer of compensation is. And if you are representing buyers, how am I going to find it out? If I'm going to so-and-so's brokerage, if so-and-so has a listing, I know their brokerage keeps a website. I'm going straight there, and I'm going to find out what that offer of compensation is right away. If I'm working with an agent, or the listing agent doesn't have any kind of website or any other tool that I'm familiar with, now it becomes more of a challenge. Maybe I have a buyer that isn't letting me look at properties that don't at least cover my fee, or at least have to cover half of my fee. So now how am I finding that out? This is probably the biggest challenge to you all, isn't in negotiating these contracts, because that's going to be a matter of discussions, but how do you communicate it effectively and efficiently? Yes, ma'am, you have a question. The question is, are these agreements available for use now? All of these agreements are in the forms library and available for use, except for this exclusive right to sell, the listing agreement, simply because it has terms in there stating that the listing agent will not put it in the MLS, communicating clearly to the seller that you can't put it in the MLS. And so you don't want to use this today, because yes, you are going to be putting it into the MLS, and so the compensation into the MLS, and so it's important that you wait for that specific form. But all the other forms are currently available for use. All of the other forms are currently available to use. So yes?
How is it handled with like the title and as far as is it the same as far as like if it's an agreement for 7% paid to my brokerage, and then out of that goes to the agent? Is that going to look different on the Alta, or is it going to be the same?
How's it going to look on the settlement statement? That's the question. Whether it's the Alta, the CD, old school HUD, sometimes cash deals, those are used. It will look just like it's always looked. Who pays it may change the side of the Alta, right? Is all of this being paid on the seller side, or is all of it being paid on the buyer side? But the Alta, CD, HUD, those forms are simply to reflect what fees are being paid out of what are the debits and credits of a transaction, and who is paying it. Whether or not it's coming out of yours, I don't think that will be separately delineated. I think it's simply going to be reflected in the same manner that it's always been reflected on the settlement statements. So, yes? So the question is, hey, most of these websites right now, they generate from the MLS, they're part of an IDX feed. Those are internet aggregators. You cannot have compensation on an internet aggregator's website. How do you stop someone from pulling that over? It's not your responsibility to stop someone from pulling it over. You're not going to put it in the MLS, so it's definitely not going to pull out of the MLS. But if somebody's reaching in and grabbing out of your private website, that's really going to be their problem. It's important that what you put in your what you reach out and grab to put in is only your own listings or listings within your own brokerage. That is expressly permitted, but you can't, if I'm in brokerage A and I put all of mine in and then I go, oh, but I've already made some phone calls and I know that brokerage C for those listings, I know what those are, and brokerage D, I know what those are. I'll just put those in mine because it'll be more efficient. No, don't do that. So whoever's maintaining that website, it's their responsibility to make sure that they're not aggregating other people's compensation outside of their own brokerage, So let's go on to the next form, which is just a simple amendment form to the compensation. These forms, again, have been created as tools for all of you. This is not to suggest that you're going to need all of these forms in every transaction. Some of these tools may be used more frequently as we all get acclimated to these sort of changes, and some of them may become utilized forever, but some of them may go by the website or wayside. And I don't want to suggest that just because there's a document to permit you to amend your compensation, that you have to do that. I've said it before and I'll say it again. I can't imagine a single person at my company that after they've worked all week and done exactly what they were supposed to do and done an excellent job at it, that I say to them, hey, do you mind if we pay you just half? Would you mind taking $2,000 less? Right? Do you say that to your plumber after they come to your house and they do exactly what was agreed to in the first place? And you go, yeah, but what do you think about just me paying you 20% less than what we first agreed? Right? That's silly. But there may be circumstances where you decide, I'm going to do that. There's always been circumstances where you've made a decision that, yeah, maybe I'll take something different. Now, this again is an amendment on the listing side, So if you're making a change to your listing agreement entirely, do that on the base agreement. I'm not going to take this amount of compensation, I'm going to take a different amount. Or we weren't going to make an offer of compensation to the buyer's agent. Now we're going to agree to make an offer of compensation because we're not getting any traction, we're not getting a lot of buyers come through. If you want to make a change across the board, you'll do that on the base agreement. But if you're going to make it specific for one transaction, maybe before you've ever taken any pictures or paid even a penny towards advertising, you just leave the house and you've got your logoed car and the neighbor comes racing over and says, whatever it costs, we want it right now. Wouldn't that be great all the time? But maybe you say to your client, well, if I'm ever going to agree to something less, this was certainly easy. Yeah, we'll do that. Or maybe it's an offer that comes in that's a lowball offer. Or maybe it's just been that listing that's been so hard, you'll do just about anything to get your seller across the finish line, and so you're willing to change your compensation. If that's the case, and if, always important, it meets your broker's guidelines on what you can and can't charge or a minimum that you charge, then this is a tool for you. At the top, you'll say what addendum number this is. Maybe you end up doing 3 different addenda because they are transaction specific, and we know that from you to do something or together to the finish line, a lot of things have to happen between appraisals and inspections and any number of things. So if it doesn't get to the finish line, this addendum is not going to matter. But if in anticipation that hopefully it will, you're going to say which addendum to your original listing agreement is this. You're going to identify your client in the real estate, and then you're going to identify at the top the specific buyers that this relates to. It will only relate to the specific buyers in that blank area that you insert. So Ann Taylor is coming through as the buyer. I've lowballed it, and your seller says, okay, if I'm going to take this offer, I certainly am going to make the same offers of compensation around that, and so we're going to change something. And we say, fine, we'll do it only for Ann if Ann gets her contract across the finish line, and so that's where you're going to insert my name. And then if that transaction doesn't happen, you're just simply reverting to your original agreement. There's nothing more that would need to be done because it was specific just to me as the buyer. And then you're going to go on to say, this is how we're amending the compensation fields. And it's anticipated that that's probably the reason that you might enter into this type of agreement. But there could be other reasons, which is why we've got the blank areas at the bottom, or other. And other might be, maybe I'll think of a better scenario than a lowball offer. I come along and I'm a cash buyer and I say, okay, I'm going to pay you full price. I'm going to pay you another $100,000 if I get all your furnishings as well. And the golf cart in the garage. Always wanted a golf cart. I don't know why. But then the golf cart in the garage, so I can just go right on up to the community center. Won't that be swell? And my seller says, this is a fantastic offer, but by the way, I'm not paying you compensation on that full price. It's a cash offer, so yeah, they wrote it all in, but we're just going to do this on the base price of the real estate, not on all this personal property that's going to convey to. Or it's a new build, and the price, the commission to be paid is only going to be based upon the primary base price and not on 48 other upgrades in the pool and the tennis courts that get added on out back. Fine, if that's what you're going to agree to, but this is the tool to change compensation or to change other terms of how you as the listing agent are going to get paid. Again, if a specific contract doesn't go to closing, it will become null and void and you'll revert to your original agreement. All right, exclusive right to sell it. Oh, pardon me, that was the rest of that. And the buyer's agency agreement. So let's go on to the buyer's agency agreement. And the buyer's agency agreement here, again, at the top, you're going to see the exact same communicated information regarding compensation. That they are not set by law, they are fully negotiable, they can be paid by any number of parties to a transaction or outside parties. Then we're going to identify who this buyer agreement is with, your brokerage, and then which buyer. If you are representing more than one buyer, if I come along and I'm going to have my spouse who is going to buy the property too, forget about the fact that maybe my spouse has horrible credit and he ends up getting taken off of the final contract because the lender says so. But if we anticipate he's going to be involved as a buyer, or maybe for professional reasons he doesn't want to be on the final deed to the property, but if he's going to be part of my transaction, you want each and every buyer that this could apply to be named on this agreement, okay? And then the buyer's going to make some representations, similar to the listing agreement, that the buyer's not bound by any other exclusive listing agreement for the same type of property that's going to be entered into. Now, if your buyer already has an exclusive listing agreement for properties in Cuyahoga County, which is up near Cleveland, guys, you may say, that's great, we're not looking for properties there. We're going to identify our properties and this is not going to conflict. But if that buyer has entered into other agreements, and buyers can get sort of limited memory at some point, right? All clients can. I've got a situation going on right now. These were calls that I was dealing with last week where the buyer and their buyer broker were in a exclusive agreement, and that buyer went ahead and bought a property without their agent. Now, I don't know whether the price was negotiated differently. The listing agent says that she asked whether or not they were represented. I don't know if the listing agent was trying to be a dual agent. There could be some ethical issues if that agent knowingly violated agency relationship. But if the client was just dishonest about the whole thing, that client might end up paying two commissions. Might pay one to one representative and another. I'm hearing some troubling things about websites that have things that are just pop-up saying, hey, if you want to see the property, click here for your representation agreement. That scares me to death. Please don't be that agent that gets people to quickly sign something and not have a meaningful conversation around it. There can be different levels of relationship, and so you might create a differently limiting agreement when you haven't established that relationship. I will say House Bill 466 is going to require brokers to establish policies on pre-qualifying buyers when it comes to finance. Just policy. So the days of just taking a Zillow lead or taking a blind lead and taking them through property as their representative may be going out the door. But this buyer is going to be asked to expressly represent that they are not represented by any other agents. Obviously, you don't want to turn a blind eye to facts that indicate differently. If you see me come through your open house with my agent, or my agent walks up to the door of your listing with me, and then the very next day I show up in your office and say, no, I'm not represented by anybody. You might want to be a little suspicious of that. But in any event, that's the first representation, that the people who are signing this agreement represent any and all buyers, and that they do have the authority, if it's not a natural person, if it's an entity who's purchasing, that they do have the authority to enter into the agreement, and they'll provide you with that proof of authority. And once again, that if that person is married, what are the names of their spouses? Because you cannot finance a property in Ohio and pledge it as a mortgage collateral without your spouse's consent, even if you are the only one buying. If I'm the only one buying and I'm married and I'm the only one going on the loan, my spouse still has to be involved. This is the time to find out I'm going through a messy divorce, or that my spouse is on mission trip in Africa and I won't see him or her for 6 more months. This is the time to have these discussions, and how is this going to work? Rather than when you're 2 days before closing and the title company asks the question and you say, oh my gosh, I had no idea she was even married, because nobody asked. So it's in there for your benefit and to avoid that circumstance. The retainer period, we're going to identify the period of time that this agreement is in effect. Again, if we don't have a long-standing relationship or haven't had an opportunity to get to know one another and establish a professional relationship, but I just called you real quick off of a listing, you are still, if you are going to be my representative, it's a different thing to open the door, but I'm unrepresented as the buyer, or open the door and I'm represented by someone else and that agent said, yeah, go ahead, take my client through. But I mean a circumstance where you want to be my representative. Maybe that means dual agency. Maybe that means only my agent. But if you are going to be my representative, we have to have a written agreement before we tour the property. So somewhere in between my phone call and you meeting me and opening that door to the property, we need to enter into some type of agreement. So maybe it's going to be a limited agreement for this one property only, and because of that we're going to make it for a shorter period of time. Maybe you're in fact establishing a good relationship with me and we're going to be looking for properties for a while, and so you set up a different timeline. But it's not the same agreement with every buyer in every circumstance. It needs to make sense for that buyer and the circumstances in which you're going to have representation with them and for them. You're going to identify in that retainer period, I'll also go on to say that this representation period is going to automatically extend if we're in the middle of a transaction and it hasn't yet closed. So let's say that we're in an agreement right now and it's set to expire July 31st, but I'm under contract to close August 8th. It's not going to terminate. This is going to automatically extend through the date of closing. So it's not like you have to go back and amend your agreement over and over again. But then we're going to identify the type of property that I want. Are we going to enter into this for 1 and 4 family residents? Are we going to enter in for any and all counties within the state? Are we going to enter into it just for a specific address? And you'll see the different areas that you can check mark there to indicate that on lines 20, 24, or 25. After line 20, it's also like or other. And while you definitely want to take really good notes of what I as a buyer am interested in, I want only 4 bedrooms, not less, and I want a pool and I want a view, and I want it to be a westerly sunset view, and I want it to be a house with certain kind of shutters and a picket fence, and this, that, and the other thing, and not more than a 7-minute walk to the school for my kids. How many times have you had buyers that said, I will only buy this kind of property, and they end up buying a different kind of property? Do not take great notes, but do not write this agreement to be so specific and so limiting that if you've written all that in here and then I end up buying that property that isn't exactly that, it wasn't the scope of our agreement. So this is not intended to be overly filled with minutia on just a specific property unless we're making it just for one specific property. I call you similar to the seller who says, hey, just for this one transaction. Maybe I'm that Zillow lead and we'll say this is only going to apply to this property, and if it's not for you, then we can go back and talk more broadly about what might make sense for you. Or we enter into this agreement because I say, look, I already know what I'm buying. Me and my neighbor want to get something together, but I still need some help. I really don't even know what I'm doing here. Help me. It's been 20 years since I last bought a property. Help me out, even though I already think I know which property I'm buying. So maybe we make it specific only to one given property. But you're going to make it different based on what makes sense for that client in those circumstances. And on section 3 is where we're going to say also the terminal period. Blank calendar days, line 33 is the terminal period, because maybe you say, okay, if you don't buy this property, I still want to make sure that if you come back to this property later, because I'm the one that dropped everything and left my family at the dinner table so that I could run over and show you this property and tell you everything about it, and I called the broker and I got their compensation, I got all the stuff that you needed in between here and there when you called me 35 minutes ago in 8 seconds. I got that and I did that for you, and then I ran around and I got you pre-qualified, and then you kind of disappeared on me. Now you're coming back to it. Maybe I'm going to have a longer terminal period there that it would still apply if you buy it or anybody on behalf, because again, we're not going to be squeezed out by a clever buyer. At the end of that paragraph, it says very plainly and very clearly in capital letters, nothing in this agreement obligates any buyer ever to make an offer or to purchase property. So just because they're signing an agreement with you for representation does not mean that they have to buy something. They certainly do not have to buy something if it doesn't apply. But then we're going to compensation, because the NAR settlement and now Ohio law says that I have to have an agreement that states the compensation that I'm owed. And that if my agreement with my own client doesn't say what a certain amount that I'm owed, I can't have any other party pay that to me. Not a seller. It can't come out of the listing agent's compensation. I can't have another third party, maybe that buyer's parents pay it to me. If my agreement doesn't say that I'm owed this money, nobody can pay me this money. So I need to say, for providing these services, what am I owed? It's going to be a dollar amount, it's going to be a percent, and it could also be a transactional fee. Again, all of these are and anything left blank is just considered zero. It does not apply. But in the center, at the end of line 45, in the center of that section 4, it says the payment of the fee shall first be satisfied or offset from any compensation offered and or agreed and paid by the listing broker and or the seller. If directed by the buyer, broker will attempt to negotiate on behalf of the buyer for payment of the fee by the seller. If the full amount of the broker's fee is not fully satisfied by the compensation paid by the listing broker and or by the seller, then the buyer shall pay the difference. The buyer shall pay the difference. You might have certain buyers in certain price ranges that say, I can fully pay this, I want the most competitive offer, we won't take any offer of compensation because it's not coming out of the listing agent's compensation, so we're not going to ask for that, and I can pay you myself. You might have clients that say, I don't have any money to pay you. How in the world is this going to work? And you say, well, the way this is going to work is it's going to now become critically important that either you buy a property where it's coming out of my compensation is fully satisfied by what comes out of the listing agent's compensation. So again, how important is it how you're setting up your listing agreements? Or I need to have this negotiated in. So maybe there isn't an offer that satisfies fully my compensation, but we could still try to negotiate that in. You tell me, do you want to look at all properties and we can try to negotiate it in no matter what? Do you want me to only show you properties that fully satisfy my compensation? You client, you tell me. And that's where you're going to start to achieve this. Something that hasn't been quite considered, and I think it's important to note too, that just because your client might have the financial resources to pay you, yes, I can pay the down payment and I've still got enough money to still pay you your compensation if we don't negotiate it. That's a debt that I owe if I'm the buyer. That may impact my loan terms. That impacts my reserves. That might impact whether I qualify for a loan. It might impact the interest rate that I get or other terms related to this loan. So just because I think I can pay it because I've got money in the bank, it's important, again, that you're working pretty thoroughly with your buyers and hopefully if there's financing with their lender as well to make sure you know the parameters under which you have to shop. What's their price point? What's the maximum loan amount? If closing costs are going to be paid, what are the parameters of the loan programs that I'm going to qualify for? And if that buyer is going to pay any compensation, does it change their ability to qualify for a loan, or does it change their interest rate or points that get paid? These things are very important and matter to your transaction. Sellers think that's not my problem. It is your problem if you're under contract with a buyer who all of a sudden doesn't get qualified or all of a sudden can't pay for it because it impacted their points and now the whole transaction's falling apart. It matters a lot. So important to have those conversations on both ends. It does say at the end of that paragraph that what's agreed here is not impacted by any other agreement. So if they're agreeing that I will be paid a certain amount of compensation in the transaction as their representative, then it's not going to change just because the seller doesn't agree to pay me. It's not going to change just because my loan parameters don't permit it. It just simply means that a transaction may not come together. So a buyer is making an obligation here, and it's important that they set up their shopping based upon what they can or can't do. All right, as we come on through here, there may be circumstances, and in section 7, there may be circumstances where you decide to take a retainer up front. So any compensation in section 4 is only going to be paid at the time of final purchase and closing. And we know that they have no obligation to make an offer to buy anything. But if I say to you as a buyer, hey, Shelly, and this is what he gets for sitting in the front row. He knew I had to pick on him at some point. Hey, Shelly, I want to buy a property. And you go, oh my gosh, that's so exciting. And I say, I just don't even know what I want. I don't know where I want. I kind of like stuff in Columbus. And I've been down to Cincinnati. And I don't know, there's like 5 or 6 counties that I'd like to go look at. And I just don't even know if I want a condo, do I want a house? Do I care about school districts? Am I going to do a private school? I don't know. And Shelly can pick up pretty quickly. Oh my gosh, she is going to be a black hole of time. Or maybe we were working earnestly for a while and he's just learned that I'm pretty particular. I got all my feng shui and I've got all my unique pieces and parts that have to come together, and I'm looking for a unicorn. But I still want him to be available on demand 17 times a week when I want to go see something. And so he decides before he renews an agreement, so either at the original agreement or before he renews or enters into a new agreement, we're going to go with a retainer here. And that retainer is due no matter what. It is not contingent upon me buying a property. I still don't have to buy a property, but if I'm just a looky-loo, or if I am just super flaky and all over the board, or I am looking for that unicorn that's going to take 10 times the amount of time, you might want to take a retainer. The retainer section states the amount that we're going to agree to, that I'm going to pay up front, and it goes on to state that that amount will offset any eventual commission that I owe in Section 4. So I'm still going to agree to pay compensation in Section 4, but let's say we agree, I'm looking for a $100,000 house. I know those don't exist anymore, just doing it for easy math. $100,000 house, and we agree up in Section 4 to 4%. And so that means that if I buy something at that amount or more or less, the compensation that's going to be owed to Shelley is going to be about $4,000 based on that agreement. But he says, I'm going to want a $4,000 retainer up front, or a $2,000 retainer, or a $1,000 retainer, whatever he says, and I agree to, it's going to offset what's owed in Section 4. It's not in addition to what's in Section 4. And it goes on to say that to the extent that it's covered then, the full amount of compensation in Section 4 is covered by the seller or comes out of the listing broker's compensation, that then I'd be refunded that. So if I give him a $2,000 retainer and then the 4% he's owed ends up getting covered by the listing agent or by the seller, then I get my money back. But if I don't buy anything, then I don't get my money back. Or if it isn't fully covered, then it goes towards the compensation that I owe in Section 4. Yes, ma'am.
Can you ask one person for a retainer and not ask another that you work with?
Yeah, that's a great question. For all of this, if I do something with one party, do I have to do that for someone else? Can I ask one party for a retainer and not ask another party for a retainer? So the short answer is yes. You don't have to agree to the same terms. You know, I gave you an example there of your super wishy-washy, I don't even know what I want buyer. And that's very different than a buyer that's pre-qualified and is laser focused. Now, no matter what you do, you can never differentially decide on terms based on a protected class status. I hope you're not saying, well, just because Ann's a woman, I'm going to charge her something more or less. Or just because she goes to my church or is of my same faith, I give different kinds of terms, or any number of circumstances that are fair housing issues. But if the type of buyer or that I am and the way that I articulate what I'm looking for warrants it, there's no reason you have to enter into the same agreement. All of this is fully negotiable, and that means for all parties, right? So that's important to recognize. I got to be careful on my time here. All right, so as we come through here, you may or may not ask for a retainer. When you get paid that retainer depends on your broker's policy. Your broker might say, I will pay that to you when it closes or when your agreement comes to an end, when the term expires. Or maybe your broker has a different policy, but that's for your broker to determine, because you're not putting that retainer in your pocket. It goes in the brokerage, and then the brokerage pays it out like anything else. So that's important to mention. Fair housing statement, again, talking about fair housing, talking about, it's a good time to talk to your buyers about those letters as well and why sellers may not. And then in Section 11, it goes on to say that you're permitted to disclose the terms of the contract to any third party, to a seller or to another agent, because you might be required to do that. Listing agents who are paying you out of their compensation may want proof that you're entitled to get the full amount of the offer, right? They might want proof. That doesn't mean you have to give them a complete copy of that agreement, but it permits you to disclose those terms that are relevant to the compensation owed. And just like with the listing agreement, we have an addendum here where you can amend your agreement. If you're going to amend it globally, do it on the base agreement. But if it is going to be for a specific transaction, so I have an agreement with my buyer that my buyer is going to pay me 3%. And we go find a house that is exactly right for my buyer, and my buyer really needs me to have the full amount of the compensation covered by the seller, but despite our best efforts, we can only get the seller to agree to 2.5%. And I'm okay with that. Not to suggest that you're required less than your agreement says. But if you decide, yes, I'm willing to do that, we can do that in this circumstance, then this is the form. And you're going to state the number of addenda, because it's to that buyer agency agreement. What number is this? It is going to be specific to particular real estate. Again, if you're changing it globally, do it on the base agreement, but it's specific to particular real estate. This is your addendum to use. And you're going to then state the different terms of what you're going to accept. You're going to state the amount that your buyer is going to owe you and the amount that the seller is going to owe you, and that will represent the total compensation that you're agreeing to take on that transaction. But if that transaction never makes it over the finish line, it doesn't appraise, the inspections aren't good, and you can't negotiate terms to have corrections done, then this will evaporate with the transaction, and you just already revert to your original agreement. Additionally, there's a section here that says this: if the buyer and the seller reach a different agreement for the amount of, or if the seller does not pay the herein stated amount, this addendum shall become null and void. What does that mean? So you get to the inspections. You've amended your agreement. You were due 3%, but you've amended it to say the buyer's going to pay me 0, the seller's going to pay me 2.5%. I've said okay, and then we get to inspections, and it needs a new furnace. It needs a new furnace, and the seller says, I'll tell you what, buyer, I'll either pay for the furnace or I'll pay your 2.5%, but I'm not paying both. Which do you want? What does every buyer say? Give me the furnace. Yeah, they're not looking out for you, and they can do that. It's not for you to say what they should or shouldn't negotiate with their seller. But if they do that, and you'd already agreed to take less, they've just nullified this, and it goes back to the original agreement where they owe you 3%. It might be important for you to point that out for them so that they can understand, oh my gosh, if I go negotiate, once my agent has agreed to take these special terms, if I go negotiate something else that changes this, then this becomes null and void. So again, trying to protect the agents and the brokers in the transaction. And then there's an other section, and maybe that other section, if that you are still get paid the full 3%, but you say, okay, we're doing the 0.5% by my client and 2.5% by the seller, maybe you're going to agree to get paid that 0.5% over time. Don't do anything without your broker's permission and consent. But if there's some other type of circumstance, or being paid on the base price only, or whatever, then that's where you can insert that. That addendum is there only to be used in those circumstances. I think we may lean into that addendum a little more early on when clients need that reassurance that there's a mechanism to amend, but it's there either way. It also can be utilized to increase. So Shelley's now shown me my 387 properties, and I fall in love with a new build, and that builder is even offering a bonus of $1,000. And Shelley says they're going to pay his full commission based on my agreement, and they're offering a bonus on top of it, which isn't in his agreement with me. And he says, hey, Ann, didn't I do you good? Remember those times that I dropped everything and left my family and my mom's 91st birthday party, and I walked out on it? Not that that would ever happen, right? Your families love your career. And I go, yeah, Shelley, you've done an amazing job. Of course I'm going to sign to amend our agreement so that you're entitled to an extra percent, or in this case, $1,000 bonus. Yeah, I can do that as well. And if that deal doesn't come together, it'll revert to the other. But at least he's got that mechanism. Or you've given horrible service to your client, and they go, yeah, I don't think so. So I don't know, but it's there so that you can amend up or down, but no matter what, in the end, you can only be paid what is supported by the agreements that you have in place. Yes, ma'am?
I'm not seeing how they can end this.
How do they end it? It is specific. You mean the addendum?
No,
So, okay, so there's a question. How do they fire you? All right. So neither the listing agreement nor the buyer representation agreement, and I have seen buyer representation agreements that have in there a standard clause of with X number of days notice, either party can terminate. That is not in this agreement, which doesn't mean, just like with your listing agreement, you all can't decide mutually to terminate your relationship. If your buyer wants to fire you, you'll have to decide whether you want to terminate. Now, does your buyer want to fire you after you're already under contract and it's 2 days before closing? You might look at that a little differently than if your buyer wants to fire you and you have exhaustingly shown them property and they're never happy and it's never fast enough and you didn't walk out on enough family events that they're never happy. You may say, I'm happy to agree to this with you, but it requires mutual agreement to terminate, and that's something for your brokers to establish with you. I know brokers that will say, yep, we're just probably terminating if they want out, and there's others that are saying, no, this is a new world order. We will never be paid if every buyer can decide on their whim after we've put in the legwork that we can just be written out of a contract, and that's how they save money on the deal. So it's not part of the standard agreement. All right. So again, we're all about finding tools to communicate, tools to work, and one of the forms that was established is this addendum. Make sure I know my time here. All right, is this addendum, which is a broker-to-broker addendum. It is the brokerage fee offer acknowledgement. This is not a contractual negotiation form. This is not a form for the buyers and sellers to agree to something different. This is a communication tool and a certification tool between brokerages. So I've gone on and on about how setting up a commission structure in which there is an offer of compensation out of your own commission might be a preferred structure for many transactions. But if your client, and the example I used earlier was 7% to be paid to the listing agent with an offer of 4%. Well, if the buyer comes along unrepresented, that listing agent is still entitled to 7% because that offer is not going to be accepted for the 4%. Right? Sort of a la the traditional. You end up saying, no, I'm keeping it all. I realize I might do double the work, but I'm just representing the seller. I'm going to get that 7%. Or the buyer comes along with an agent who's entitled to 2%, or a flat rate is agreed upon, and that buyer's agent is entitled to $500. And that only works out to be a fraction of a percent. That doesn't mean that that buyer's agent's going to get that 4%. They're not entitled to it. It's not supported by the written agreement. So this is where a listing agent might want that buyer's agent to certify, what are you entitled to receive? I need you to certify that for me so that I know you're entitled to receive what portion of this. Regardless, it's a tool. So up at the top, it's going to be completed. Maybe in the end it's completed entirely by all parties. Or maybe this is something that a listing agent has a stack of with their other marketing and collateral materials inside the property, where a buyer's agent can take one of these and it says very clearly, what's the offer of compensation? Is it so much dollars, so much percent, and is that coming out of the listing agent, in which case now that buyer's agent already knows they don't have to negotiate it, or is it to be paid in addition to whatever's going to the listing agent? So the buyer's agent takes this just so they have it. Maybe this is uploaded to that brokerage website where they only have listings for brokerage. It cannot be attached to the MLS, but it can be attached in other places. And then when the offer goes back, maybe that buyer's agent fills out the bottom portion to indicate this is what I'm entitled to receive. So I'm just validating that for you up front. but it's a broker-to-broker tool. Maybe before we get into this listing and before I show it, because I've got the luxury of time, I know that this weekend, and here we are on Monday, and I know that on Friday I've got out-of-town buyers coming in, and so I'm just trying to get this all lined up because they've already told me what parameters they want in the properties they go see, or they haven't set those parameters, but I just want to know. I just want to have it teed up so that I can communicate it to them. You send these around to all of the listing agents who already have properties that you think you're interested in showing to your buyers, and everybody fills this out. But it's a broker-to-broker communication tool and maybe a certification tool for the buyer's agent to certify what their agreements reflect they're entitled to receive. But it wasn't originally anticipated, and a lot of the brokers or a lot of the people on the forums committee thought that would be a helpful tool. Yes, you have a question. Question is, can that be uploaded into showing time? If showing time was not part of the MLS, you would have been able to, but it is part of the MLS. Showing time cannot include any offer compensation. Anything attached to the MLS, accessed through the MLS, cannot include a communication compensation. You can have it on your own website, on your broker's own website. You can have it in the property. You can have it a million other places, but not on the MLS or related fields. Yes, ma'am? What about attachment on easy offer? I'm going to caution you all to not think that I have greater knowledge of technology than I do. I happen to know showing time is part of the MLS. I don't know what easy offer is. It's part of dot loop. So dot loop's not part of the MLS. Dot loop's not part of the MLS. So if there's a feature in dot loop where I can go in there and I guess easy offer, and I can see, I'd say probably property disclosures are in there, and I can see other things related to the property. Maybe they've had renovations done or other improvements, and you've got all of those materials in there for me to see why it's worth all of that. You can have it in there if it's part of dot loop, because that's not part of the MLS. I'm going to take that question and then yours. Yes, sir.
So I've got 7% on the listing, 4% going to the buyer.
Mm-hmm. So the question is, I've got 7% in Section 4 of my listing agreement, and then we have 4% as an offer to the buyer's agent. And really in this example, it doesn't matter if it's out of or in addition to, but it's 4% coming out of, or that's an offer to the buyer's agent. What if the buyer's agent's only entitled to 3%? What if the buyer's agent's only entitled to 3%? Since it's the 7%, and I'm going to assume in this number scenario it's coming out of yours, that buyer's agent only gets 3%, unless that buyer's agent amends their agreement for that property to say, no, you're entitled to 4% for that one. So if they amended it, then they would be entitled to it for that one before they tour the property, but you can't claim something that's not supported, and so that additional percent would stay with the listing agent. Now, if it was 2% in Section 4 to the listing agent and an offer of 4% to a buyer's agent, then if the buyer's agent comes only entitled to 3%, no amendments, it's just 3%, then that listing agent's still only getting 2%. In that case, that other percent just doesn't get paid by the seller. So it does matter, is it out of or in addition to? It does matter. And then, yes, ma'am.
On that easy offer thing, and maybe relative to other broker sites, are you able to put a link in the MLS that directs you to the compensation?
Don't put a link that directs you to something compensation related only. There's nothing wrong with you saying more information, see my website. For more information, give me a call. More information, text such and such. But to do links that tie to compensation, I would stay away from something that is going to in some way, shape, or form exclusively look like you're putting in there trying to link to the MLS compensation only. Right? Yes, back in the corner. Okay, so, and again, we're, don't over-assume my technological understandings, but, so they're talking more so about easy offer and links and whatever. If all of these links tie to compensation, stay away from that, I think, too, that we'll continue to see more and more guidance come from the MLS as they start to realize that people are trying to find very specific ways and creative ways in order to address these things. Yes, question right here.
Does a percentage amendment have to be done, or addendum have to be done prior to showing the home?
Does the percentage addendum have to be done prior to showing the home? The MLS rules require that before touring a property, you have a written agreement stating what you're entitled to. So I would say yes. Yes, you need to find out before you go through if there's a greater offer than I otherwise had agreed to. Before we tour this home, we want to accordingly. We want to enter into an agreement. So let's go on to our last form, and then we'll still have time for questions. The broker compensation contract addendum. Now, this is a contract addendum between buyer and seller. The last form we just went through is a broker-to-broker communication tool. If you want to have everybody sign off on it, and by everybody I mean each brokerage, to confirm, yes, we're both certifying, we're both on the same page, that's great. But this is a contract addendum, and as with any contract addendum, it is only going to be valid if the parties to the contract agree to it and sign off on it. This addendum probably is getting filled out and sent over as part of the original offer and the original contract. You'll mark in the, I'm referring to Dayton's contract, you'll mark in the contract the section, I think it's 18, where you say other addenda, and you'll identify it, just like you would if you were putting an escalation clause addenda or some other type of addenda to be attached to that offer. You want to communicate this as soon as possible. Not to say it couldn't come in later in the transaction, maybe at the time of an appraisal or something else, but it is intended really so that this can be negotiated and included with all of the original terms and conditions that the parties are going to agree to. So you're going to identify the buyer, the real estate, you're going to say attached to and part of the contract to purchase dated, which will correlate with your actual contract to purchase. And then in the middle of the page there, it goes on to say that this addendum does not amend or supersede any other compensation agreements, buyer agency agreement, exclusive right to represent, exclusive right to sell, or other agreements between either and or both of the parties and their or its agents. So just because buyer and seller only negotiate for the seller to pay part of the compensation doesn't nullify the rest of the compensation that's already due to that buyer's agent in their buyer's agency agreement. I think it's a best practice if you're going to utilize this as part of your contract, and I know some who are saying, yeah, I'm going to use it on my contract just to clarify everything. Whether or not anything is further negotiated, maybe my buyer's still going to pay everything to me as the buyer's agent and the seller everything to theirs, but we're just going to do this for clarity and transparency. That's great. I think it's great to do that, but I would also say it would be a best practice to utilize this form in such a way that does indicate 100% of the compensation, at least to the buyer's agent. You'll see as you go down, and the buyer's presenting the offer, and as they present the offer, they'll identify their buyer broker representative, and then they're going to indicate what the buyer's going to pay as compensation to their agent and what the seller's going to pay. And this may just simply reiterate what the seller already put out there as an offer to be paid, or it might be an additional negotiation. But I would utilize it to fully indicate the amount of compensation and who's paying what. Now, it says at the bottom that the section below, optional use to confirm and clarify seller paid commissions to seller's broker representative is only required if any amounts are to be negotiated to be paid by the buyer. So not very often that a buyer wants to jump up and pay the listing agent commission as well. But there are circumstances, if I was putting an offer on a property and I intended to get to get financing for that, I might recognize that even though my budget says I can go through the roof on my price offer and I can out every other offer out there, it's not going to appraise. So if I want to have financing, I still have to worry about an appraisal. So maybe I decide that the way to differentiate myself is to give them a pretty good price offer that I think maximizes the amount of the appraisal, but then offer to pay a dollar amount or a percentage amount of the listing agent's compensation. So it can be utilized in that way. It may not be all the time. You don't have to fill out the bottom portion just because you're negotiating the buyer's compensation. If you're not negotiating anything relative to the seller's agent's compensation, you don't have to fill out the bottom portion, or you can just for clarity's sake. That's certainly fine. But this is a tool for buyers and sellers to negotiate the compensation to be paid. And then on the next page, again, we've got some blank lines. Maybe for other special terms or conditions, this again might be, well, we're building in some furniture, so compensation is only going to be paid based upon a percent of the sale price for the real estate, which is such and such dollar amount, and nothing based on the real property, the personal property, the furniture, which is a different amount. You're not going to do something like that if it's finance. Aren't going to be okay with that. But that it's again there to be utilized as a tool that might be helpful. So again, all of the terms and conditions you put in here may or may not equal the total compensation, but I think it's a best practice to write this in such a way that it does total the full compensation. And then you're going to identify who is paying what, and each party is representing, again, to one another, that there are no other brokers involved, no other compensation owed to any other parties. If a party is false in that representation, that is their liability. That is their liability. Buyer-broker agreements have always been a good idea to make sure that as the buyer's agent, you didn't get cut out of a for sale by owner, a new build where they don't go tell the builder that they're represented, or they just call the listing agent and go through the property themselves and don't tell them that they have an agent. Whether or not your client is honest in what they communicate to another party, they are still obligated to pay you what is agreed in this agreement here. So again, we've drank through the fire hose. We have about 9 minutes, but that's a lot of time for some questions, and I can still stick around after. But yes, we got a question right back here. Go ahead. Right. Okay. That's a lot. This is more like a thought dump. A thought dump. Okay. How do I articulate this as a question? So let me say. So the broker-to-broker form, broker-to-broker, which is our second to last form, the commission acknowledgement. If I'm the I think a lot of times I probably want that filled out. I want the other party, especially if my client is offering something that is on the high end of what's customary, or a bonus or something in excess of what's maybe customary, but maybe I just make it standard practice that I get this filled out all the time. That's certainly fine. But how does this get communicated? How does this all work out in the end? Again, as a buyer's agent, under the terms of the settlement, you are only permitted to be paid what your agreement states. Even if you later amend it before you tour the property, you can only be paid up to the amount that's in writing. So if the seller is making an offer of compensation that exceeds what you're entitled to, and you're not going to further amend, and you're fine with that, you're like, look, we're not upsetting any other apple carts. Maybe it makes your offer more attractive to the listing agent to say, I love this agent, we love working with them. But that, if there is an offer of compensation that is greater than what the buyer's agent is entitled to, it does not get paid to the buyer's agent. So then the question becomes, two parts. The first question is, what happens to that 1%? If what was being paid to the buyer's agent is out of the listing agent's compensation, it stays with the listing agent. It stays with the listing agent. If it was being paid in addition to what is paid to the listing agent, then it stays with the seller. But the buyer's agent is not going to capture that. And then how do you communicate that? How is that communicated? So compensation's always had to be communicated to title companies, but how does this get communicated between buyers and sellers? And that's why they created that broker-to-broker form. But maybe you say that's too many darn forms. I don't want 8,000 forms in my transaction if I don't need them. You can still put it on your addendum just for clarity's sake, and if you're not asking another party to pay anything over and above, it's really not being utilized in that circumstance as a negotiating tool. You're using it as just a tool to be clear and to communicate the information. Maybe you want to write it into the lines of the contract because I'm not asking anybody to pay anything else. I'm just stating a fact that buyer's agent is entitled to X% commission or X dollars compensation. You cannot put a range on the buyer's side. So again, any compensation in your agreement with your client on the buyer's side must be objectively ascertainable and cannot be a range unless it says, in this circumstance I'm owed this amount, in that circumstance I'm owed that, but then you have to say what circumstance you're in. But you can't say anything and everything owed by or paid by the seller. It can't be an ambiguous range that, how does somebody know which, if it's 3 to 5%, how do I know which it is? So I'd have to know, it'd have to be objectively ascertainable. Yes?
Relating to this question, is it allowed to, let's say, you work with Lucy for years and I'm like, hey, I can give an extra percent if you will amend this by are we allowed to, since it's already established prior?
Can you? So what if the seller's offering something that exceeds what you're entitled to? If you have not yet toured the property, you can amend your agreement for that property. You could amend it globally, but you could also do it just for that property. That would say you're entitled to a different amount for that property and that transaction.
But how do we, so who's disclosing prior to, that's what I think where the confusion.
So, yeah. The communication, or the question is, how's this all getting communicated? Who knows what? Who knows which way? Listing agent, it is your responsibility to communicate at the earliest moment possible. And for those of you, and we've heard there are some that don't like to communicate, you don't want to be putting yourselves in the position to have to do this via phone call, right? And then if you were the buyer's agent, are you comfortable with just a phone call that I don't have anything in writing and proof? That's why we created that broker-to-broker communication. But it finds methods to efficiently, effectively, and verifiably communicate the compensation offer from your client, because unfortunately it can't be used on the MLS anymore. Find a way to communicate that, and then as the buyer's agent, you want to find a way to validate back what you're being paid, and that's why that broker-to-broker form is useful. Does it have to be in writing? If everybody's fine with it, and everybody like, hey, I'm just asking you, you're entitled to this full amount, and you go, yes, I am. it obviously needs to be able to be proven if it ever comes to it. But what's required in any given transaction, I don't know. I think we're going to also see some standards of practice evolve where it becomes a little more customary and standard. I am going to say I'm going to stay around for another 20, 30 minutes. But guys, we're at the end of our 2 hours. Thank you very much. There's a lot to digest, but I fully believe in a couple of months it's going to start to really set in and be old hat. So if you need to go right ahead and I'll stick around. Thanks, guys.